Hello, colleagues, and welcome to the Risk Management and Insurance module of the PMT course in 2025. My name is Thomas Harben. Just a little bit of background. I am employed by the Lpiif, the Legal Practitioners Indemnity Insurance Fund, and my position is that of General Manager. My functions at the Lpiif include serving as the head of the risk management control function, the general legal counsel of the company, and it's in those capacities that I got involved in training of legal practitioners, because the risk that comes from the legal practitioner environment is something very important to us. We need to assist the profession to avoid the occurrence of risks and thus claims. I am an admitted attorney. I was admitted in 1997. I practiced for just over a decade and then took up an in-house role. I've been with the Lpiif since 2009. I also write a lot of material for Terebus. You'll find it in the practice management column of that publication, and write the articles for the Risk Alert Bulletin that's published by the Lpiif. My work involves litigation. That's litigation against the company as an entity, high-risk litigation, or that involving novel legal or policy issues. I've been involved in teaching PMT for about a decade, and also often do presentations to individual law firms and as well as to various structures and organizations in the profession. Start just with the introduction. This presentation will cover the main risks facing legal practitioners, what measures can be implemented to mitigate those risks. I'll explain the respective roles of the Lpiif and the Fidelity Fund, and provide some general information on the insurance products available in the market as a risk transfer measure. And then lastly, we'll deal with the assignment. Just a few terms of engagement. Please only communicate with me via the e-leader platform. Do not write to me directly, text me, or phone me. And I will only deal with content-related questions. Anything admin related, that's assignment dates, if you have not received material, difficulty in uploading assignments, that usually comes out literally at 11 p.m. when the assignments need to be submitted by midnight on the due date. Please do not send your assignments to me. Do not send me queries regarding marks, regarding certificates, regarding the quizzes. Those are all admin related. Direct them to the team at LEAD. And if you send any communication to me outside of the official channel, it will be deleted without being read. Colleagues, questions that are posted on the e-leader platform will not only, the answers will not only assist you, but they'll also assist any of the other delegates who may be struggling with the same questions. And also, for the sake of transparency, let's rather communicate on that platform that's open to everybody in each intake. Every week I'll be available for 2 hours to answer questions. That's on a Tuesday and Thursday from 4 p.m. to 5 p.m. Please post your questions At any time, even outside of those hours, but specifically for those hours, I will be available I will be on the eLeader platform answering questions. And very importantly, colleagues, and I say this based on experience in the previous years with this course. This is not a course that you can think that on the last day before the assignment is due, you'll scrap something together and hope to pass. You will not. Please read the entire manual. The manual is relatively short. It's the length of an average judgment delivered by the Supreme Court of Appeal. So it's like reading one judgment. Also watch all the videos and also read the pointers that I'll post from time to time on the eLeader platform. Those will all assist you in being successful in this course. The entire presentation will be made available to LEAD so that it can share it with you. Going on to what the high-risk areas of practice are. And high risk, we assess high risk because those are areas of practice where practitioners are prone to make errors that result in either claims or regulatory action against them. And also those are the same types of claims that provide the highest end value of professional liability, theft, or other claims against legal practices. And just looking at all the claims notified, whether it's to the Lpiif, to the commercial insurance market, or to the Fidelity Fund, the area of practice with the highest claims is road accident fund work. On the Lpiif side, we get the vast majority of our claims come from circumstances where practitioners have been instructed by clients to pursue a claim against the RAF. They do not pursue the claim in time. The claim that's prescribed in the practitioner's hands, and the practitioner is sued. Undersettled claims are also a risk. Undersettlement happens where a practitioner is running a claim against the RAF. They use the widely worded power of attorney to settle the claim, and they settle it for less than it's worth. The client then sues the attorney for the difference between what they received in settlement and what the actual settlement amount was. Litigation claims are also a problem. Once again, prescription is a problem in litigation claims. Practitioners not filing the statutory notifications in time. That's with claims against the state. Litigation not being properly attended to. Over-reliance on counsel or on junior staff and not supervising them properly, and also not taking proper instructions. I'm not talking about financial instructions. I'm talking about details of what actually occurred, in what the circumstances were that led to the client believing that they could pursue litigation. So take detailed instructions from clients to help mitigate that. Conveyancing, a number of problems there. The failure to adequately supervise staff. I know in the nature of conveyancing work, there's a heavy reliance on paralegals and conveyancing secretaries. But at the end of the day, the buck stops with the practitioner. We have recently been notified of claims where, in one instance, the transfer wasn't registered. The secretary, however, took a standard letter, did not change it, and sent it off to the client. The client thought that the transfer had taken place when they didn't. We've also had instances of claims where paralegals and conveyancing secretaries have lied and said to, whether it's to the clients or whether it's to their principals, that matters have been lodged and registered when they have not. And that leads to problems. Cybercrime. We'll talk a lot about cybercrime later on in the presentation. But cybercrime claims, business email compromise, change of banking details, primarily target conveyancers. They are the people that primarily receive emails providing fraudulent bank details, and they are duped by those emails into making payments into those fraudulent bank accounts. Bridging finance. Bridging finance is a huge problem. Sometimes in conveyancing transactions, bridging finance needs to be applied for, and it is applied for, and the transaction goes through, and the bridging finance company would have required the conveyancer to sign an undertaking. The conveyancers, for a whole host of reasons, whether there aren't sufficient funds, or whether it was an error on their part, do not pay the bridging finance the amount, the bridging finance company the amount due, and then have to face claims. Also, we have conveyancers not properly following the terms of the agreement between the parties. We have those paying out funds before registration. Paying out funds before registration is a huge concern. If a conveyancer is sitting with a deposit or part of the purchase price in trust, and then before the transfer takes place, before transfer is registered, then you'll find typically the seller will say that nothing can go wrong in the transaction. Please pay me part or all of the money you are holding in trust, because there's something else I need the funds for. For a whole host of reasons, the transfer doesn't go through. The owner of those funds then looks to the conveyancer for a refund. There's another problem with estate agents who sometimes request that conveyancers pay them the estate agent's commission up front or before registration, and they threaten not to give the firm work. Please do not do that. Or else you'll put yourself at risk. I have written an article on that, making reference to the Code of Conduct for Legal Practitioners, as well as making a reference to the rules and the Code of Conduct for Property Practitioners. If anybody is interested in that article, I can share it. I often say to attorneys, if you've got estate agents that are putting you under pressure, just send them a copy of that article to explain what the risks are. And it's important that if in the circumstances that I've sketched, where the purchaser has paid money into your trust account, and whether it be the seller or whether it be the estate agent or any other party who requires the money before the transaction is registered at the deeds office, explain the risks to the purchaser, what would happen if you do that, and rather get an indemnity from them, so that if something goes wrong, they do not hold you liable, and get instructions from them in writing. Then also we have conveyancers failing to scrutinize the conditions in title deeds and not conducting something as simple as a deed search to see what conditions are with the ownership is, the size of the property, all the information which can be obtained relatively easily from a deed search. When it comes to the administration of deceased estates, the theft of trust funds or assets is a huge problem. We have practitioners not dealing with matters timeously, delegating these matters to junior staff to run with, not answering queries from the master, where bond of security is issued, not answering queries from the insurance company, whether it be the Lpiif or another insurance company that has issued that bond of security, and just not reporting to interested parties. And then finally, commercial matters. There the problems we've seen are inadequate FICA being conducted on parties, and actually that applies to every area of work. Over-reliance on precedents and not following the instructions with regard to agreements. I'll also add not doing proper CIPC checks to see if these are if you're dealing with companies, not checking what the full names of the companies are, what the proper names, registration numbers, etc. I've just taken a snapshot of those areas that provide the highest number of claims. And if you would give me any area of law, I can tell you where the mistakes are. If we look at, for example, the first two, claims against the RAF and litigation, and the matters of prescription. If I'll go to a very niche area of legal practice, competition law. All our competition law claims have arisen because of a failure to follow timelines. We've had an increase in claims against legal practitioners since about 2007, and there are a number of reasons for these. Number one, the profession has grown substantially over the last few years, whereas the economy has stagnated, and the legal service market is not big enough to serve everybody, so it's become very saturated in certain areas. Secondly, there's been an emergence of new risks: cybercrime, bridging finance, and artificial intelligence. I'll talk about those three areas as we go through the presentation. And with just something else with conveyancing in particular, because it's cyclical, it's dependent on what is happening in the property market. So when you have dips in the property market, you also have dips in the conveyancing market. Times firms are left exposed because they're sitting with high staff numbers, then have to retrench, and those people that are left in the firm then have to pick up the work that their colleagues would have done, and thus become stretched. And the same can apply to any area of the law. The changes to the RAF model, this is the introduction of the board notices in 2021 and then 2022, also affected those firms doing road accident fund claims. If you look at the numbers of the profession in South Africa, a significant portion does road accident fund work. The Lpiif is currently engaged in litigation to set aside the board notice 271 of 2022. There's another matter that's linked to that's running parallel to the Lpiif matter that deals with board notice 58 of 2021. If you want to read the current status of those matters, please go onto the Lpiif website, and on the risk management page, you can scroll down, look at the risk alert bulletin, and if you click on the latest risk alert bulletin, whenever you click on it, in the last 2 years, the first article deals with the board notice updates on what's happening with that litigation. I'm recording this in the last week of February 2025, that both the matters are currently before the Supreme Court of Appeal. For those colleagues who will be doing the PMT course later in the year, they may, by then the matter may be set down for hearing. But please look at the risk alert bulletin. The latest bulletin will tell you what the latest position is. And then firms also fail to implement adequate training programs and adequate supervision of staff. Adequate training programs is a huge problem in the profession. We see some practitioners, and I emphasize that some, not all, who are admitted and they start their own practices, but in dealing with them we realize that there are huge gaps in their training. There are huge gaps in what they should know at that stage of their careers and what they actually know. I have written an article on the need for adequate training programs in firms, and that's in the practice management column of Lpiif. If anybody is interested in reading it, if you just go onto the Lpiif website, and if you click on columns, scroll down to practice management, all the articles are written there, and you'll be able to see from the titles. But if you can't find it, please post a message on the e-leader platform, and I'll give you the exact date that it was published. And the same applies for anything else that I talk about that I've written. Inadequate supervision of staff, as I mentioned earlier, in respect of the conveyancing market, the over-reliance on conveyancing secretaries and paralegals, but the same happens in other areas of the law too. I know that you have very well-trained, very competent support staff, but at the end of the day, the buck stops with you. You need to check the work that they do. And then the over-reliance on practice management programs. Practice management programs make our work easy, and there are several available in the market for different areas of practice. But those do not replace the attorney. The client at the end of the day is not paying for a computer to do its work. It's paying for you to apply your expertise as an attorney. Clients have also become increasingly aware of their rights. As I've said in previous years, gone are the days where what lawyers say is the gospel. Clients have learned that they can question what lawyers say, and they can test. And going back to my earlier point about the saturation of the market and the changes in the RAF model, this has meant that some attorneys that were pursuing that type of work have had to pursue other areas of work. One of them is suing attorneys, medical professions, and even people in the built environment. So those are all professional liability claims that people are now pursuing more often because their former bread and butter is closing, and we cannot judge them for that. People need to do work with wherever they can take it. But linked to that is a situation of attorneys taking on work in areas that they may not be adequately experienced in or qualified to do. And that also leads to claims. And then economic recession. Actuarial models for claims against the legal profession, whether it be in South Africa or whether it be in other jurisdictions, so that at times of negative economic performance or economic slumps, claims against professionals, whether it's lawyers or other professionals, increase. Some clients may suffer losses and need to find someone to recover those losses from. Unfortunately, it can be lawyers. And then the aftermath of the COVID-19 pandemic. Yes, the pandemic is largely behind us as a health risk, but the circumstances and the conditions that we endured when we were in the throes of the pandemic still persist. A lot of firms had to close, firms had to downscale, leading to people going still to start practices when they perhaps didn't plan to, leading to people being unable to pay their debts. In the manual, I've referred to one case where a legal practitioner couldn't pay his rent. There's also an article that will be published in Rebus in 2025, where I've covered how courts have dealt with mental health challenges of legal professionals. In one of the cases I referred to there, you'll see that that practitioner suffered through several events, including that her career did not flow as she had expected. The flow of her career that she had anticipated was affected by the COVID-19 pandemic, which only exacerbated her mental health challenges. And then, yes, there are gaps in the regulatory model and the education model. In South Africa, we don't have a risk-based model of regulating the profession, so sometimes the regulator, that's the Legal Practice Council, is slow to act against recalcitrant practitioners. The problems with the education the model I've already addressed, but because of the slowness of the regulator to act, those practitioners who are doing wrong could continue doing wrong for a long time before they are eventually stopped by being struck off or suspended. I'll start with the Lpiif, that's the Legal Practitioners Indemnity Insurance Fund. This is a non-life, what used to be called in the old days a short-term insurance company that was established by the Fidelity Fund in 1993. We are always surprised at how many practitioners do not know that the Lpiif exists or what it does. It's a non-profit company and it provides the services referred to in Section 77 of the Legal Practice Act. Prior to the Legal Practice Act, it was Section 40 of the Attorneys Act that set up the statutory framework for the Lpiif. We are currently funded by way of a single premium that's paid annually by the Fidelity Fund. The Fidelity Fund has, for the last few years, been saying that this will change and practitioners will be called upon to make a payment, make a contribution to the Lpiif funding. The date for the implementation of that, as well as the amount that practitioners will be expected to pay, are something that the Fidelity Fund will announce. That is a competency of the Fidelity Fund. If you look at Section 77 as well as Section 74 of the Legal Practice Act, it's not a competency of the Lpiif. We will follow what the Fidelity Fund says. And just at this point, I want to just note something. You'll see that the Legal Practice Act was passed 11 years ago now. Most of the sections of that act came into effect on the 1st of November 2018. That's more than 6 years ago. Regrettably, in the PMT assignment, we still have attorneys referring to the Attorneys Act. Colleagues, we are lawyers. If we cannot read the one piece of legislation that governs our profession, then, with respect, we are in trouble. If you refer to the Attorneys Act in your assignment, you have failed. That is not a threat, that's a promise, because it also shows number one, that you do not know the law, and secondly, that you've neither read the manual, you've not watched the video, and you've not read the presentation. The Lpiif also provides professional indemnity insurance to all legal practitioners with Fidelity Fund certificates. That's attorneys on the one hand, and also advocates practicing with the Fertility Fund certificate. We provide bonds of security to attorneys who are seeking appointment as executors of deceased estates. I'll just talk a little bit about the bonds of security because they aren't covered in the presentation. If a firm is seeking appointment as an executor of a deceased estate and a bond of security is provided, you can apply to the Lpiif. Look for the terms and conditions and the application form on the Lpiif website under the executor bonds page. We provide bonds of security where the attorney will be the executor. Do not provide where the attorney will be an agent. So remember, only where the attorney will be the executor will be responsible for the day-to-day administration of the estate. And we provide bonds up to a value of 5 million rands per estate, or will give firms an aggregate exposure of 20 million. So you can, that's what you have available at no cost, because that's another service that we provide to the profession at no cost. And then we provide risk management services to the profession. The risk management services take various forms. We provide a prescription alert service. That's an electronic diary system where you can register your matters, and the prescription alert service will send you reminders whether it's a prescription date or next step has to be taken in a matter. For registration of the prescription alert service, you can also go onto the prescription alert page on the Lpiif website. We offer risk management training also at no cost to legal practitioners and their staff. If you would like us to come to your firm, no matter where you are in the country, we can come. We can do that training even virtually. It's provided at no cost to you. I've mentioned the articles we publish. We also embark on litigation to address risk issues. The most topical one is that relating to the RAF board notices, but we've done many other tranches of litigation on other issues before that. As I've mentioned, that matter is currently before the Supreme Court of Appeal. We provide the material that you've had to use for this course. We've also comment on draft legislation as the way that affects the risks in the profession. The Lpiif policy, there's a copy of the policy that's attached to the manual. Please read it. Alternatively, you'll also find a copy on our website. The policy is issued annually. It's one policy for the entire profession. That's why it's called a master policy. Our insurance year runs from the 1st of July of one year to the 30th of June of the following year. So when I talk about an insurance year, I talk about that period. And practitioners without fertility fund certificates will not be covered. Please look at clauses 5 and 6 of the policy. So if you are obliged to apply for a fertility fund certificate and you do not have one for whatever reason, or for part of the year you did not have one, you will not be covered for that period for which you did not have a fertility fund certificate. If you want to know who is obliged to apply for a fertility fund certificate, please read section 84 of the Legal Practice Act, and also read sections 33 and 34. But in short, it's partners or directors in firms. And then the amount of cover is determined by the number of partners or directors in the firm on the date that the cause of action arose. So if you look at your manual and the policy, the second last page has the annual amount of cover. You'll see it's provided on a sliding scale. So a sole practitioner has a sole practitioner has 1,562,500. 1,562,500 rands. That's what a sole practitioner will get, and that's in fact the limit between 1 and 6 partners, and then after that it goes up to a maximum for firms of 14 partners or more at 3,125,500. So that's 3,125,500. That amount is per year. Advocates with fertility fund certificates are treated as sole practitioners, so they also get the 1,562,500 per annum. And then the excess is also determined by the number of partners or slash directors in the firm on the date that the cause of action arose. If you look at the last page of the policy, you'll see a table there with the applicable excess. And please note that there's a higher excess paid for conveyancing matters and RAF matters or matters where there's an element of dishonesty. In addition to the higher excess for RAF matters, if the claim was not registered on the prescription alert unit, or having been registered, you did not follow reminders sent by that unit, we add another 5% as a penalty deductible. It's important to note that cover is provided per firm, not per director. We often have people writing to us insisting that each director is entitled to separate cover. That's not the case. Read the wording of the policy. The annual amount of cover is defined. Read who is a director is referred to, or partner is referred to as a principal in the policy. Read that definition and read clauses 5 and 6, and then the 2 annexes that I've just referred to. And you have one limit per year, and then the staff in the firm, whether it's professional assistants or associates and candidate attorneys and secretaries and paralegals and messengers, are all covered under the limit of indemnity of a firm. So that amount has to pick up all the errors made by anybody in the firm. If firms are looking for an additional amount of cover, so I could use a sole practitioner with 1,562,500. If you feel that you need 5 million rands cover, you could go to the top-up market, to the commercial market. That means that all the other insurers that are operating in South Africa, and you can buy what is commonly referred to as top-up insurance. That's an amount of insurance above the Lpiif limit. And that's it. Insurers won't sell you cover from the ground up, so to speak, because you've already got this amount that the Lpiif provides. They only sell you additional cover. If you're talking about professional indemnity liability, that is it's called top-up insurance. If your firm is doing a tender or serving on the panels of banks or other entities that set a minimum amount of cover that they provide, you'll also need to go to the top-up market for that. Top-up cover is placed through an insurance broker. We have no relationship with any insurer, with any broker in the top-up market. We are completely independent. We do not have any favorites. We do not deal with them. All your dealings with them are independently of us. It's between you and them. So if anybody claims that they are linked somehow to the Lpiif, that is simply not true. And from time to time, people contact us wanting certificates of insurance. We do not provide those. If you look at the professional indemnity page on the Lpiif website, we explain why. And we stopped providing those about 12 or 13 years ago. So don't come to us for a certificate of insurance if you are doing a tender or trying to make a bid to an entity or company to serve on their panel. what they will require from you is a certificate of insurance that comes from the top-up market. Remember, under the Lpiif policy, as long as you have a fertility fund certificate, you are automatically covered. There are a number of exclusions to the Lpiif policy. I'll summarize them very quickly. First is trading debts. The most common trading debt claim we get is when clients sue for a refund of fees. That's not covered. Then misappropriation or unauthorized borrowing of trust money. Misappropriation is just theft of trust money. I've also written an article in the Rebels explaining those two concepts, because unauthorized borrowing is just theft by another name. And if you look at a lot of the striking off claims where attorneys have stolen trust monies, sometimes they contend that they've made a loan from the clients. The courts have given that argument short shrift, and the attorneys concerned have been struck off. Then risks that could more appropriately be insured under another policy. The cybercrime, for example, you can buy a cybercrime policy. I'll explain those later. Misappropriation of trust funds, you could also buy it in the open market. Or public liability. I'll talk about insurance policies for misappropriation later. And then judgments from foreign courts. So if there's a judgment against your firm that was somebody has litigated it against your firm in a foreign jurisdiction and gotten judgments against you, you cannot claim from the Lpiif. A lot of insurance policies have a similar provision, and that's for several reasons, but mainly because imagine if a South African firm was sued in North America, whether it's in the US or whether it's in Canada. The amount of damages that they award in those jurisdictions are very high, so we wouldn't be able to cover them. If you're providing investment advice, that's not covered, or if you invest funds where there are no legal services being provided. It's the same as also look at that in the context of another exclusion I'll talk about later, where you just act as a conduit. So examples out of E and F are where an attorney may carry out a transaction. Let's just say a conveyancing transaction. They're involved in the property has been transferred, it's been registered, and then the seller says, don't pay the money to me, please hold on to it, because I'm worried that I may be going through a divorce soon and do not want my spouse to get their hands on those funds, or I'm looking for another investment opportunity, but in the meantime you hold on to the money, or you hold on to the money because I don't want it in my hands because I don't want SARS to come after me for that income. There's no, your legal services have been completed, and the attorney is effectively acting as a bank, and they won't be covered. So if there's a fine, a penalty, or an order to pay their bonus their bonus proprius, that isn't covered. That is not compensation. If you're doing work for an entity defined in the National Housing Act, you're also on your own. Bridging finance, that's unrelated to the property that is the subject of a conveyancing transaction. If you read the Lpiif policy clause 16I, you'll see that we'll only cover bridging finance in very limited circumstances. It must be related to the property that's the subject of that conveyancing transaction. And secondly, only if it relates to costs such as outstanding municipal rates and taxes, levies owing to a homeowners association, or an amount owing to SARS. You'll see the first two you will need in order to get a clearance certificate. That's why we cover them. So bridging finance, we've seen claims where people have applied for bridging finance to pay for weddings, or to pay for vehicles, or to go on holiday. Those are not covered. That's firstly. And then secondly, if you have bridging finance, these days people are taking bridging finance in order to deal with personal injury matters. If you take those, you are on your own. That's a trading debt, and it will be funds that claim doesn't arise from a breach of a professional duty. That's a contractual issue between you and the bridging finance company. So please remember that if you're applying for bridging finance to pay for medical legal examinations and reports in personal injury matters, those claims we won't deal with. From time to time in the legal profession, we have to give undertakings. But please do not give an unqualified undertaking, the performance of which is dependent on someone else. Only give undertakings for those things within your control. Only give an undertaking to pay money if you actually have it in your trust account. Don't give the undertaking and the client say that they'll have the money to you in a few days, but they need the transaction to go on. Do not give those. And then breaches that are not those of a professional duty. One example I've just given is if a bridging finance company sues you for bridging finance that was provided for a personal injury matter. Sometimes council may sue you, or your landlord may sue you, saying that you breached a contract. That's not a breach of a professional duty, so that's still covered. Business rescue practitioners are excluded because business rescue practitioners really become officers of the company where they've been appointed, firstly, and secondly, there are bonds of security and insurance policies that you can get in the open market for that. If you're merely acting as a conduit of funds, this is linked to what I said earlier about investments that won't be covered. An example of an attorney acting merely as a conduit of funds, or as a paymaster, as sometimes it's referred to in the insurance market, you have party A and party B enter into a contract. In terms of that contract, party A needs to make payment to party B. And party A doesn't trust party B. So party A pays the money to the attorney and says, please pay it over to party B. When I say that when I give you the go ahead. In those cases, you haven't provided legal services, you're just a conduit. Defamation claims. These are claims where the attorney is sued for defamation. A lot of these arise in litigation, particularly family law matters, where the attorneys get involved in the fight between their respective clients and say things which other people may find offensive, and there are defamation claims and countersuits, and we don't cover those. We are in the business of providing compensation where there are claims by third parties arising out of a breach of your professional duties towards the third parties. We are not in the business of insuring egos, so we cannot cover them. Cybercrime, I'll deal with in a lot of detail later, but cybercrime claims are excluded. Claims by related entities, what we mean there is that because of your standing as a legal practitioner, you may be asked to sit on boards of companies or other entities from time to time, and by all means go and sit on them. And some people sit on those boards and ask to use those as opportunities to channel work to their firms. If in those circumstances, the firm does something wrong and that entity sues the firm, you will not be covered, because people often say to the entities in those cases, it's fine, sue me, I've got the free insurance from the Lpiif, they'll pay you, and then our relationship can go on. Life doesn't work like that. It won't happen. And if you do work on the law of a foreign country where you aren't admitted, you'll also not be covered. If you are sitting in South Africa and there's a legal question relating to the law of any other country in the world. Rather, instruct someone in that country who's an expert in that area to deal with to provide you with an opinion, deal with that aspect of the matter. Do not do work where you're in countries where you are not admitted. If your activities are conducted in violation of the Legal Practice Act, you'll also be on your own. Simple. No insurer can cover someone for an intentional illegal act. So if you breach the Legal Practice Act, you have practiced illegally, done something unlawful. You can't be covered. And then claims arising out of dishonesty. That's addressed in clause 18 and not in clause 16. Please have a look at that. We also don't cover those. So how does the LPIF deal with claims? Where a practitioner becomes aware of circumstances that may lead to a claim, and just to pause there, circumstances that may lead to a claim. You may get a letter of demand against you. A client may express or a third party may express their unhappiness with you and say that they will institute action against you for losses they have suffered. Or looking through your own matters, you may see that there has been a mistake. If any of those happen, please report it to the LPIF. Please notify us in writing within 1 week of finding out. Send your email to claims@lpif.co.za. Prepare a detailed background report, and don't prepare a report that sugarcoats things. You're dealing with us as your insurers. You can be honest with us. So, address the error, the omission, or the breach of mandate, or whatever it is that the other party is complaining about. Address it. If a matter just slipped through the cracks, if you forgot about a court date, if you miscalculated your prescription period, please address it there. Tell us. Be honest with us so we can deal with it. And then you will be required to fill in a claim form and the risk management questionnaire. Be honest with us. If you are not honest with us in notifying the claim, you run your risk of your claim being rejected or repudiated. We will require your entire file, including your handwritten notes, your sticky notes, your file notes, everything that's in there, all the correspondence, all the pleadings, all the agreements, if it's a commercial matter, even if it's even drafts. Please give that all to us, and do not try and pull out documents that you think you don't want us to see, because they'll come out in the litigation, and you'll be embarrassed, and we'll be embarrassed, and we'll withdraw, and you'll be on your own. If your firm has top-up insurance, that's top-up insurance. Remember I said that's professional indemnity insurance that you buy from the commercial market. It's over and above the LPIF limit. If you have that insurance, notify your broker or insurer simultaneously with notifying the LPIF. You do not want to get into trouble with any of your insurers for late notification of a claim. And what will happen if there's top-up insurance? It's also involved. Well, the LPIF will always be involved because it's your primary insurer. The top-up insurance and the LPIF will work hand in hand in dealing with the claim on your behalf. If there's a defense, an attorney on the LPIF will be appointed to conduct your defense. If there's no defense, we see that you are liable, we'll settle the claim and we'll pay it if it's something that's covered by the LPIF. But the LPIF team will have a discussion with you. They'll explain to you how they've reached that conclusion and when it will be paid and how much you need to pay in respect of your excess. Remember, the excess is in the tables I referred to earlier. The LPIF has has about 10 highly experienced legal advisors in its claims team, and they deal with this every day of their lives. So any decisions that they make, they would have made using their expertise and experience. And furthermore, we have several steps internally that a matter will go through, whether the decision is to defend or to pay. So please be respectful to my colleagues that sit in the claims team, and also be respectful to and cooperate with the attorneys that are appointed by the Lpiif, because they are there to look after your interests. If you do not cooperate with us or with our attorneys, we'll also withdraw the cover. Do not make any admissions, any denials, or try to cede your rights, the rights in terms of the claim. The issue of cession, I think in the manual I've referred to the matter of Propel Specialized Finance versus Lpiif, the Lpiif before 1 November 2018 was called Lpiif. But in the Propel matter, that firm sought to cede its rights in terms of the Lpiif policy to a bridging finance company. We successfully overcame that in the Western Cape High Court. We also successfully overcame it on appeal in the Supreme Court of Appeal. Those attorneys acting for a party that has a claim against a legal practitioner, please do not sue us. Third parties, do not have any rights in terms of the Lpiif policy. Only an insured, as defined in the Lpiif policy, has a claim. Also think of the res inter alios maxim. You cannot sue in terms of a contract that you aren't a part of and that gives you no rights. So third parties, your action lies against the firm involved. That firm can decide whether it will sue us. Another analogy I often have to give to attorneys who decide they want to sue us: remember that a divorce action is really a termination of the marriage relationship. If you are not a spouse in a marriage relationship, you cannot go and institute divorce proceedings. So it's the same with this contract of insurance. It's between us and the insured. Third parties cannot involve themselves in that. And then if you find out that you've made a mistake, please refer your client to another attorney, and if they would like their file, make sure that if you give them the original, that you make copies of absolutely everything. Alternatively, hold on to the original and give them a copy so they can go to. We'll need that file in order to help assess your matter and to run your defense. The assessment is that we will conduct, whether it's conducted internally or to our panel attorneys, is first of all, we'll check whether the claim is covered by the Lpiif policy. If not, you'll be informed. If it is, we'll go on to the second stage. We then look at whether you are liable or not. If you are liable, we'll pay. If not, we'll defend. And then thirdly, we'll also look at the quantum of the claim to see how much you are in for. And as I've said, at every step of this journey, you will be included. So please read the communication that comes from the Lpiif team and from your top-up insurers and comply. Just on the test for liability, a claim against an attorney can either be framed in delict, so the person claiming will say that you've breached the duty of care that you owe them. It can be in contract, they'll allege that you breached a term of the mandate, or a breach of a fiduciary duty. And then the test for liability has been set out in several cases. The cases are referred to in the manual at paragraph 3.6.1. Please read those cases carefully. In one sentence, the test is whether you've made a mistake that a reasonable attorney in those circumstances would have made. And then also look at paragraphs 3.11 and 3.13 of the Code of Conduct, because they also prescribe what an attorney should do. And there's a number of resources that you can have a look at for this part. The Lpiif website, on the risk management page, there's a detailed document with risk management tips. Please download it, please read it, please share it with people inside your firm. A lot of it is common sense, but share it. Help empower other people while you are empowering yourself. You can look at chapters 4 and 5 of Professor Bernard Wessel's book, The Legal Profession in South Africa. It explains the contractual liability and delictual liability of attorneys. If you read the May 2022 edition of the Risk Alert Bulletin, you'll see they have answered 10 questions which often come. But those 10 questions give you a concise overview of the Lpiif and what it does. So if you, after watching this video, you are uncertain, if after watching the video and reading the manual, please read that. It's only 8 pages, that May 2022 edition, and it will answer a lot of your questions. And if in doubt about who the Lpiif insures, read the March 2021 edition of the Risk Alert Bulletin. If you are in doubt about the excess, read the December 2020 edition. Those will provide very brief summaries, but I think that they provide sufficient information to assist anybody. And if you do not know where to find the Risk Alert Bulletin, it's on the risk management page of the Lpiif website. You scroll down, get Risk Alert Bulletin. They are provided in chronological order, the latest first, and you'll see, you'll find what you're looking for there. Thanks you very much, colleagues, for watching this part of the video. This is the end of part 1. Look forward to seeing you again in part 2, which will be a separate video. Thank you.